So let's get into this matter. It's been very thorny for months now. Senator Natasha Akpoti-Uduaghan against the Senate, well, the Senate President. Of course, the Senate has been joined, particularly because of a suspension that came from all of the controversy. So we're also being joined on the program this morning by Yemi Adamuleko, who is Executive Director, Enough is Enough Nigeria. That's EIE Nigeria. She joins us virtually from Lagos. And of course, as you've seen, Mr. Cletus Obun is a former lawmaker, academic and public affairs analyst. Ladies and gentlemen, good morning and thank you for joining us. I want to quickly refer to the statement that the Chairman, Senate Committee on Media and Public Affairs, Senator Yemi Adamuleko, put out yesterday about the court judgment, saying that the Senate is yet to be served with a certified true copy of the said judgment, and said, consequently, the Senate is not able to make a decision and shall refrain from taking any steps that may prejudice its legal position. And I'll begin with you, Madam. In the light of this, the Senate saying, well, we've not gotten the CTC to that judgment, and Senator Natasha Akpoti-Uduaghan saying, well, I'm going to be resuming on Tuesday. Will it be in order? Is there anything stopping her from resuming, particularly because there's still some sort of lack of clarity as to what the court really said, since they're saying they've not gotten the CTC?
Definitely. I think for her as well. I mean, I think that's what I understand. And also as a citizen, if you look at it, media have reported different things. So some houses reported that the judge said it was unconstitutional. Some just said, she said it was excessive. Now, if it was unconstitutional, then that, in my view, gives Senator Natasha the right to show up, because she's basically said the Senate violated the ground norm of the country. Some media houses reported that she's meant to apologize to the Senate. Other media houses reported that she's meant to apologize to the court for contempt. So I think, to your point, because there are varied reports of what the judge actually said, I think my understanding is that the judge has 7 days. I listened to a gentleman speak the other day, and he was talking about there are some courts where you actually get it immediately. I've also listened to Mr. Falana talk about how there's been an incident where what was said in open court was then different when the CTC came out. And obviously the judge was reported to the NJC and sanctioned. So I think it's absolutely important to wait till the CCT is released. And to Senator Natasha's statement, I would maybe assume she said she assumed she would have gotten the CCT by then. So, but definitely on both her side and the Senate side, it's certainly wise to wait for the CTC.
Right. So let me ask Honorable Obo as well. But we are clear, at least, to some of the things that were said. Again, sometimes as you said, as Yemi Adamuleko said, what is in the CTC might be different from what was said in court, so tread with caution. But in the light of the part around, well, being excessive, unconstitutional, the suspension for 6 months, and then the conversation around, can the court order another arm of government, in this sense, the legislature, what to do, because some people have raised that point. What do you make, first, of the Senate's decision to now suspend her for 6 months, which we understand the court has said was excessive and unconstitutional? Honorable Obo, that's for you.
To say unconstitutional or not, let me say that what prompted and made me accept to intervene here is on account of the fact of the institution of the Senate and the confusion that has arisen on account of this very matter, which also tries to put the judiciary on trial, unnecessarily so. This morning, let me say to Nigerians that we should not at any time attempt to do what we are doing. First, why are we engaging in guesswork when the document is to come out? That decision was taken on Friday. Today is Monday. 72 hours later, we are getting ourselves so busy and so frenzied for a matter that is simple. Like my sister there said, and all of us have maintained, let us get the certified true copy. With that, everything is settled once it is cast in stone, in black and white. That having been said, let me get to make the point that it can never be unconstitutional, because if Section 60 gives powers to the parliament to make its own rules, what comes out of those rules becomes a subsidiary legislation that emanates from the Constitution. So what makes it unconstitutional? People just use terminologies because we are in a free world and you say free speech. So you just make any comment and get away with it. Section 60 has been cited, which gives powers to the parliament, whether it is State House of Assembly, whether it is councillors in a particular local government, whether it is House of Reps, they should make their rules. Once those rules are made, they become part of the Constitution. So they become subsidiary legislation and therefore part of the ground norm. Having said so, what now becomes excessive? The judge is given discretion, for example, to adjourn cases in order to get more facts or to get certain documents. That adjournment is at the discretion of a judge. If the judge says, come next month, some litigant gets up and says it is excessive extension of time or adjournment of the matter. It should have been tomorrow in 24 hours. Another will say 1 month is too short, depending on who is before the court and what he desires of the court. So at that exercise of discretion, it should be left to the body or the person or the institution that has powers to use that discretion. Whether that discretion is judicially used or arbitrarily used is a matter for time to tell, and for those who are to take that decision to make. If there are appellate bodies to take a decision about how that discretion is to be exercised, that becomes a different matter completely. So by our jurisprudence, once you have given the quasi-judicial powers to the parliament to punish its own members, to reward its own members, to regulate its own houses and to regulate its own activities, then you must leave it to make that discretion without gagging it by the use of a judicial. If that is excessive, the judge is not even in a position to interfere. It's as good as the parliament saying that a judge, having given an excessive punishment, maximum punishment, when you say an option of a fine or imprisonment or both, and the judge decides to give both a fine and you say it is excessive, that is double jeopardy, that it is excessive of the judge to have done so. Which other court is to say that? And you go to the appeal court, the appeal court maintains that what the lower court said is correct. And you go to the Supreme Court and it says what the lower courts have said is correct. And you turn around and say because you are a parliamentarian, you are a senator, or you are sitting in the Senate Judiciary Committee, comes out to say it is excessive. That becomes a mere opinion. So a decision has been taken by the parliament as enshrined in the Constitution by the powers conferred on it by the Constitution of Nigeria. To that extent, whatever is said cannot be said to be excessive, because in the exercise of its discretionary powers granted by the Constitution, you cannot turn around and say it is excessive or not.
Cletus, are you saying that? Just a moment, Mr. Cletus.
Before now, I had made the point.
Just a moment.
I had made the point that.
Just a moment. Okay. If you can hear me, just a moment. So the point you've raised, because we haven't seen the CTC as correctly as you put it. Are you saying that on issues like this, because of Section 60 of the Constitution, the court doesn't have powers to adjudicate over this issue? Is that what you're saying in essence? So that we're clear on your position.
The Constitution is also clear that once a matter is before a parliament for discussion, no court in Nigeria shall interfere, especially as it relates to bills, the making of laws. If the parliament, any parliament is making a law, that process of making the law cannot be adjudicated upon by any court in Nigeria. It is constitutional. But you can challenge the outcome of that law. For instance, a law is made to say no woman should come to National Assembly. A woman or person who feels aggrieved by that can challenge that law and the court can set that law aside. But the process of making it cannot be challenged by any court and by anybody in Nigeria. You can challenge the outcome of a law, but not the process of making that law. You must allow that law to come out. It is when the law comes out that you say, this section of the law, I do not agree with it. Court interpret it for us because it is either discriminatory or on account of its provisions. But you cannot, in the process of making a law, do that. And that is why that issue of the order that they are talking about, that the parliament disobeyed the court order when it proceeded to punish Natasha, that provision is again quashed by the Constitution, which provides that the process of making a law and the regulation of the activities of a parliament resides with the parliament under Section 60. Under that provision, there is no judge that would have accurately and properly be sitting, any court will lack jurisdiction to interfere in the process of taking decisions about the disciplinary measures of any committee.
All right, let's take it
to that extent. I can tell you.
Yes, just a moment. Let's take it to Yemi.
It is not proper for any court to interfere. So also, if a matter is before a court, no parliament can talk on that issue. If a matter is before a court of law in Nigeria, no parliament shall take any decision or take any step on such a matter. So the two are complementary, and the intention is not to interfere with another arm of government.
All right, let's take it to Yemi. I'm sure you have a response to what Mr. Cletus has actually said. But in addition to that, are you seeing a lacuna here, or the complementary role is being overlapped in some instances? Because there's a tricky position here. Because I've read the Legislative House's powers and privileges, and I'm not sure I saw what was said in terms of punitive measure or reprimand is to the effect that it must not exceed a particular time, I mean the entire legislative period. So maybe the discretion allows the National Assembly to be able to say 6 months, 3 months, or whatever it is. But the tricky part here is to the effect that it is not just the individual you're punishing an entire constituency. So which is why the commentaries around excessive, let's even leave the court, is part of the conversation. What do you make of it?
Excellent, thank you. And I think I'll start with the point he made. First of all, I'm not a lawyer, as a caveat. So I'm commenting as a layman and an interested party. But I'll start with the point he made that we're putting the judiciary on trial. We should put the judiciary on trial, because when the judiciary makes judgments that go against common sense, that go against the laws of the land, they put themselves on trial. And Justice Nyako, very interestingly, was mentioned in the ADC case. She was the one that gave, how does a presidential candidate get up and decides he wants to upturn the structure of the party? And you give them judgment. And I mean, she has a track record that I will not go into, but she is also at the center of this as well, in the way that it's almost as if she's playing to the gallery, trying to make the political class okay, but also seeing the fact that these things really don't make sense and actually give judgment on the merits of the case. I disagree with the gentleman that spoke. There are at least 10 legal precedents that show that it is illegal the courts have declared that it is illegal to suspend a sitting assembly member because they were elected to represent people. So if you want to punish them, and I think the point you made around maybe 6 months, I mean, I'm not going to get into the terminology of it, but the judge herself said if you are sitting for 161 days, and by the time she was 121, by the time she was making the pronouncement, Senator Natasha had been out of the National Assembly for 125 days. How is that not punishing the people that sent her there to represent them? Now, that hasn't stopped her from representing her, not representing, but working for her people. But that is legitimate thought. And if there's precedent up to the appeal court, and this is from 2019 of Friday Sonny in Kogi, we've got Jigawa State, Sonny Yaku, we've got the Court of Appeal in 2020, restating 3 Ondo Assembly members against frivolous suspensions. It is clear that the National Assembly or the State House of Assembly is exercising powers to want to punish for whatever offense, but in the process, then punishing the people that you're representing. And then lastly, the court is saying that that is excessive. Find other ways of saying that they did, quote unquote, badly, or they shouldn't have done what they did, and not deprive the people that they represent. I mean, I know that Senator Natasha's constituents is in court saying that you're depriving us the Senate is depriving them of representation. But I think it is important that we don't, and these are legal precedents. So if if Judge Nyako is aware of this precedent, then her statement should have been very clear in saying that this is not just excessive, unconstitutional, and the Senate has no right. I mean, it's not just not excessive, but that Senator Natasha should be there representing her people. There's legal precedents to support it. It's not, she didn't pull it out of the air, but she wasn't as definitive or as clear as she should have been. Then again, I haven't seen the full CTC, so let me caveat with that.
All right.
So, I mean, just to your point, I don't think there's a lacuna in that sense. I think the clarity is ultimately the Senate's structure did not bring you in. You are not an appointee of the Senate president. You are elected by your people, and the only means to punish you if your people who elected you think you're not representing them is to recall you. And we saw how that went. And again, that was engineered by Senator Natasha's opponents. And we've seen, I mean, I'm sure you guys saw sheets of those things that were clearly the same signatures, like literally the same signatories. It didn't meet the threshold of INEC and it was thrown out. So that's the way you recall someone that's not representing you, not people who don't like the way you speak or look or talk, saying that they want to punish you by keeping you out of the chambers.
All right, thank you for that point. Honorable Cletus, I'd like to, at the risk of overflogging the issue, take you up on your position about the judiciary, sort of interfering with the position of the Senate that has, a constitutional right to its rules and, legislative proceedings. In the court's decision in the case of Senator Natasha Akpoti-Uduaghan, the judge faulted the provision of Chapter 8 of the Senate Standing Rules, as well as Section 14 of the Legislative Houses Powers and Privileges Act, declaring both to be overreaching. And can't we say that there are lessons to be learned in the case of Senator Ali Ndume, former Deputy Senate President, Senator Ovio Mwagege, speaking to their suspension, in one case nullifying it and in other case declaring it to be excessive? Aren't there lessons to be learned in this case? And in the case of the Legislative Powers and Privileges Act that grants immunity on lawmakers on certain things, on things that they say on the floor of the assembly, what if they said things that were, that bordered on national interest? In that case, don't you see a case where it is the checks and balances that is operating here to sort of protect and uphold the integrity of the institutions involved?
Well, let me, because the parliament is relatively a young arm of government in Nigeria. Each time it comes up, it is thrown out. So people don't tend to understand the workings of parliament. And incidentally, Nigeria is a member of the International Parliamentary Union. And it is also a member of the African Parliamentary Union. What that means is that parliaments all over the world basically have ground norms below which they must not descend. So because we are in Nigeria does not in any way, what we can only do is, for instance, to shape in the US, where we are copying our own for over 250 years of their democracy. We have seen parliamentarians not just being suspended, but being expelled, thrown out of parliament physically, by the parliament, not by the people who recalled them, who voted for them. In Nigeria, we have not reached that stage yet. Because we are still managing, emerging democracy, people see some of these things as strange. So I am not in any way shocked. I am only being patient to believe that with time we will keep learning. Because if we take even our own community, even as basic as the community level of our parliament, that is taking decisions in a community in an age grade, not to talk about an organized form which is governed by rules. You cannot, even among robbers, there are rules. You must obey those rules. Once you cannot, you leave. Even in football teams, if you can't obey and keep disciplinary routines of training and other things, you are taken out, punished. Sometimes even for getting a yellow card, you are punished. For getting a red card for a club, you are punished. Just not because you can play and therefore without you the team can't do. So if you come into a parliament, as in this case, and do not obey the rules, the judge in the first place, the Nyako you are talking about, the Justice Nyako, had already made the point that it goes without saying that the parliament has a right to do that. So the parliament has obeyed its own rules, followed them up, taken the necessary steps. What she was only doing was being adversary. She was expressing an opinion. So what we might appeal in Nigeria here now is to say, look, on account of what has been going on, let us amend those rules.
All right.
As they stand today, There is nothing anybody in Nigeria, even the courts, can do about that once those decisions are taken.
Well, there you go.
They can do about it.
And I think we're also back to the point where we started, that, well, the CTC has not been seen yet. So we'll just wait to find out and read those letters and be sure what the court really ordered and what was an opinion. But we have to thank you so much, Honorable Cletus Obo, for your time, as well as Yemi Adamoleku. It's been a pleasure speaking with you on this matter.
Thank you.
We'll take a quick break now, and when we return, there's a Nigerian who is traveling around Africa by road, and he's had some very, very interesting encounters in some African countries. We'll speak with him in a moment. Stay with us.